Almost every contested dissolution of marriage case has a requirement that the parties create through the court, at mediation, or on their own volition privately through attorneys or by themselves as pro se litigants, a marital settlement agreement. What is a marital settlement agreement? What does it accomplish? Why does it have to be filed with the court? A marital settlement agreement is largely based on the parties' financial affidavits. What are your assets? What are your liabilities? Do you own cars? Do you own homes together? Do you have bank accounts together? Stock market or other 401k and investment accounts together? Do those need to be equitably divided, which is the overall intent and the spirit of a marital settlement agreement, that your assets and liabilities will be equitably divided, which means justly and fairly. Now, there's no one set absolute way in which this occurs in most cases, but that is the principle that is supposed to be a guidepost for the parties in creating the marital settlement agreement. It must be filed because the court needs to know how these things will be divided. Otherwise, your case could be eventually set aside, deemed to be incomplete, or the court might decide outright before it's finalized in the first place that not enough work has been performed on the case and that not everything is solved, settled, divided properly. And you really ought to consider the value of resolving all or as many issues in your case as you possibly can before any final judgment is issued, because that is in the party's best interest in most, if not all, cases. The marital settlement agreement in most cases must be signed and notarized by both parties in order to be enforceable, and should account for as much as possible of the assets and the debts as well. Credit card debt, student loan debt, mortgage loan debt, home equity loan debt, and the rest. Thank you.